People confuse unfair labor practice to that of unfair treatment in Namibia, and I think today I've just decided that I explain to people what the distinction is and when it amounts to unfair labor practice, so that they can avoid referring disputes that are wrong, and only when a case starts and then they are informed, no, you brought a wrong dispute, and it's a waste of time, and again, by the time you are to start, a certain time frame has passed. So today's discussion, we are going to look into what unfair labor practice is, as promised in my previous video where I was talking about constructive dismissal. I promised that I'm going to discuss about unfair labor practice. Hello viewers, my name's BIANCA-LET'S talk, and today we are talking about unfair labor practice. And wait, listen up to the end, and then you can learn more from your employment. This video applies to both employers and employees. I'm not for any party. I'm just here to shed light to both sides, that is the employer and the employees. And whoever is interested, subscribe to my YouTube channel, hit notification button so that whenever I post anything about labor matters or lifestyle issues, you are able to get notification and learn something from it. So today I'm discussing about unfair labor practice, and in terms of the Namibian law, unfair labor practice is governed in relation with Section 50, Clause 1. Now, most people confuse certain treatment at workplace to be that of unfair labor practice, when it's not the case, because Section 51 puts up, or the list is so exhaustive on what amounts to unfair labor practice. And also the issue is, be careful with that Section 50, because most of the elements, again, under Section 50, it's about employer and or employer's organization against the union. The only time that section talks about to the employee direct, you'll find that it's Section 51E. It's the one that deals with employees directly, whereby there's an issue of unilaterally changing the terms and conditions of employment. What does that mean? Where the employer changes the terms and conditions of employment without consulting an employee. So with that, you find an employee has a right in law to refer a dispute to the Office of the Labour Commissioner of unfair labour practice. While I'm still at that point, people should, or employees and employers, should take note to say the only circumstance when an employee will be entitled to payment under a claim of unfair labor practice is if there was unlawful deduction, or maybe the terms and conditions that were changed by the employer deals with the deductions or change of salary and so forth. But otherwise, a claim of unfair labor practice is normally not monetary payment. It's an order that the Office of the Labour Commissioner or the court will give, directing an employer to do something or not to do something that they are doing to an employee or employees. So under Section 50, you realize the list is so exhaustive. So whenever you are having an issue at work, both employer or employees, understand that section before you refer a dispute for an employee. And if the dispute has been referred, as an employer, that's your basis to raise a preliminary issue. Understand the content if the dispute that has been referred to, it falls within that definition of what amounts to unfair labor practice in terms of Section 50. If it doesn't, it's a good point to raise and say, look, I'm raising a preliminary issue here. We are not dealing with a case of unfair labor practice. And even employees, before you are to refer, understand what amounts to unfair labor practice, so that you don't get to face this preliminary issue and then you say, no, the Office of the Labour Commissioner is corrupt. When there is no corruption, it's a wrong dispute that you would have referred to. Then another section that governs unfair labour practice is that of Section 48. Now, 48 is read hand in hand with Section 33. Section 33 of the Labour Act deals with procedure. There has to be a right procedure and also substantive aspect, which is there has to be a valid and fair reason in order for an employee to be dismissed. Now, before the whole dismissal starts, while you are still being subjected to a disciplinary hearing, an employee, if believed there is no valid and fair reason, or there is a procedure somewhere that is wrong, has also a right in law, refer a dispute to the Office of the Labour Commissioner of unfair labour practice under that heading of 48 incorporating 33, stating that I have been unfairly treated by being subjected to a disciplinary hearing because there is no valid and fair reason for me to be subjected to this disciplinary hearing. The employer has no evidence. The employer, not even evidence, let me not even go there. The employer has no justifiable reason to put me to a disciplinary hearing. One good example I can give in that relation, it could be maybe there was no proper investigation done, or the investigation, maybe you were never consulted, and had you been consulted, they would have gotten the full information, and as a result, they're having wrong information, and that wrong information is just time wasting. You know, they could have consulted the employee, get full details, maybe given proper documentation for them to make a proper recommendation whether you should be subjected to a disciplinary hearing or not. But because everything is not done properly, or maybe there is a certain belief to say they just want to subject you to a disciplinary hearing so that they find you wanting and dismiss you, when in actual fact it's not the case. So it's all those things that you can refer a dispute to the Office of the Labour Commissioner for unfair dismissal. The treatment that you get from work, normally that people you find, no, I was unfairly treated, it's unfair labor practice because the employer ended up, maybe doing something. Then you go like, but that does not fall in the definition of unfair labor practice. That is completely unfair treatment. So there's need to make a distinction. Certain things that we experience at work is just unfair treatment, not unfair labor practice. Don't take unfair labor practice to mean the retro sense of it's unfair labor practice. No. It's defined what amounts to unfair labor practice. And unfair labor practice, it's not always you're going to get monetary payment from it. No. The only time you can get under unfair labor practice case is if the case relates to money deduction, which was not done properly, or maybe there was a deduction that is not supposed to be done, which is changing the terms and conditions of your employment. Not just mere thing because you are asked to do something, or you feel the other one is paid more than you are paid. Then you want to say, no, it's unfair labor practice because my colleague were doing the same job is receiving a higher salary than me. No, that is unfair treatment. Refer a right to dispute. Employers, if you see that, knock it down with a preliminary issue by raising issues of the issue or the dispute is not proper before the Office of the Labour Commissioner, because the issue raised does not fall within the definition in terms of the law. So, viewers, subscribe to my YouTube channel, hit the notification button, follow me, leave a comment, let me know what else you'd want me to discuss. But in brief, that is the only thing I'll leave you with for tonight. Don't mind my jacket, it's very cold and I apologize for that. And in case I'm not very clear, it's just the cold that is killing me. But yeah, thank you so much.